testified, based upon the information that we presented, that she was in fact the victim of domestic violence, and that those people are known to take responsibility for conduct that they didn't do to protect themselves and to protect the children that they're trying to protect. There's only one other person who knows exactly what happened in the living arrangements between my client, the child, and Mr. Staples. And he has never stepped up to explain or to accuse. The government's case contends that my client is a demonic individual who caused was the sole individual who caused these injuries to the child. Despite the fact they know that Mr. Stagels was present allegedly throughout the whole thing, could not possibly have not known what was allegedly taking place. There were other people who lived in the residence who would have known that what the circumstances of this child were and turned a blind eye to it, apparently. The government contends that my client was so controlling and so cunning that she could prevent her father, the child's father, from doing anything to save his own child, despite the obvious awareness or witness to the circumstances. The government has contended that my client is so domineering of the father that even from her jail cell, he could prevent him from seeking the care and aid that the child needed. My client has been charged and convicted of depraved indifference regarding the death of Brooke. But that fault, and clearly there is fault for the circumstances under which Brooke passed, but that fault is shared, in my opinion. It's shared with the father, who was complicit, if not the actor, regarding the circumstances. And it is the fault of everyone who claimed throughout this circumstance that they were aware of the conditions, that they were aware of the circumstances, and chose to do nothing. They had no more legal relationship with the child than my client did. They had no more legal obligation to the child than my client did. But now, after the fact, they contend that they were aware and they chose not to act. So all of this, in my opinion, brings us to the conclusion that this awareness of even third parties who at some distance or some extended relationship from the child knew of the circumstances only reinforces what we tried to present to the court. So now I'm in a position where I have to ask for leniency concerning my client, and I do, or we do. The statute, as Ms. Van Stratic has indicated, offers the court a great deal of discretion regarding these circumstances. And either sentence, any sentence really, imposes the possibility of life regarding the circumstances. There are two children that my client dearly loves and cares for, who are deprived of their mother. There is a community which is driven by bloodlust, in my opinion, regarding the circumstances, and is looking for vengeance regarding this matter. But they don't know who I know. They don't know that my client is in fact remorseful, and that my client could not communicate could not express what the real facts of her living arrangement were, because, like so many who suffer from domestic violence, she has a shield that prevents her from coming forward with that information as I am trying to present it to her. Because she's built up a callous over the years about emotion or trying to promote herself or her own cause. I've asked Erica, or we've asked Erica, if she wants to make a statement regarding this, and she's declined not to, and that's because of our legal position. So I don't want you to misinterpret that. Nothing that you do today can change the consequences of what took place. But what you have the power to do is to afford my client the opportunity to rebuild regarding these circumstances. It's odd that in our community currently that the opioid crisis and the heroin crisis is really taking the lives of people who are using heroin at a remarkable rate. The odd thing is that her incarceration has resulted in her not potentially becoming a victim of her own heroin addiction. But this is a sensitive individual, in my opinion, who deserves the right to be able to start anew. And I ask you to afford her that opportunity regarding these circumstances. Thank you.
Thank you very much, Mr. Bell. Ms. Bell, the law affords you the opportunity to say something to me on your own behalf. I know what your attorney has said that you declined, but let me hear from you. Do you have anything to say to me at this time?
No,
Mr. Kisberg, let me just ask you this. Who's here for Ms. Bell?
I don't know.
Anybody?
my parents are my mom,
Your mother is here?
my sister.
We have family members here, Judge. I'm sorry I didn't get a chance to meet with them before.
And let me just start out by saying I ask that because it has seemed to me throughout this how utterly alone your life seems to have been, and I want to commend Mr. Kisberg and Ms. Wesley on their representation of you. They're probably the only true heroes you've ever had in your life, and they did an amazing job. All right. Let me just state first the sentencing range for each offense of which the defendant has been convicted. Murder in the second degree, the law mandates an indeterminate sentence of between 15 to life up to 25 years to life, meaning that the defendant, upon having served the first number of that formulation, would then become eligible for parole, and her release would then, at that time, be up to the New York State Parole Board, and if released, she would then be on parole supervision for the rest of her life, unless she were to violate, which means that she would be returned to jail. Manslaughter in the first degree, she would have to serve the minimum portion of the sentence. It's a determinate sentence of whatever I impose. And at that time, she would then be on post-release supervision for 5 years, during which time, again, a violation would send her back to prison up to the balance of the post-release supervision. The sentence on each of those would have to run concurrent, meaning that each conviction arose out of the same set of facts, and thus the law mandates that any sentence to be imposed would run together. Secondly, let me state the purpose of any sentence is mandated by the law and by case law. It's been said that the determination of an appropriate sentence requires the exercise of discretion after due consideration given to, among other things, the crime charged, the particular circumstances of the individual before the court, and the purpose of a penal sanction, which is societal protection, rehabilitation, deterrence, and in some authorities, retribution. As such, a sentencing process requires, on an individual basis, a delicate balance of the numerous factors relating not only to the nature of the crime and the particular circumstances of the offender, but also, again, the objectives of our penal sanctions. Retribution, I mentioned, which is allowed under certain authorities, simply means a punishment which is imposed simply because the person deserves it. And while some authorities might deny that a sentence take into account retribution or vengeance, it's been said even by Justice Stewart of the United States Supreme Court that the instinct for retribution is part of the nature of man, and channeling that instinct in the administration of criminal justice serves an important purpose in promoting the stability of a society governed by law. And when people begin to believe that organized society is unwilling or unable to impose upon criminal offenders the punishment they, quote, deserve, then there are sown the seeds of anarchy, of self-help, vigilante justice, and lynch law. Retribution from a New York appellate court is the reaffirmation of societal norms for the purpose of maintaining the respect for the norms themselves, which are community condemnation and the community's emotional desire to punish the offender. I mentioned this in the context of what would seem to be an epidemic of violence against children. And I would mention the quote that murder is the paradigm of its age, and the paradigm of this age is violence against children, both sexual and physical. I am just one judge here out of many in Monroe County handling felony prosecutions for physical abuse. I have dozens of cases in just 1 year. The other judges have equal numbers. There are no words to describe the horror of the cases that come before me. And this is not a new phenomenon, at least not to our decade, is why in 1990 the legislature amended and added to the definitions of murder, manslaughter, and assault to heighten the penalties for acts committed against children less than 11 years old. All right, so that is the sentencing ranges, and those are the factors that go into a sentence. Let me turn to the defendant. I've read the pre-sentence investigation. I've read it many times, Ms. Bell. I think I'm struck initially by how little there is in it. Certainly, I've seen more. For mitigating factors, I note the following. You don't have much of a criminal record. I know that the criminal record that you do have was driven by your heroin addiction. You have 2 children, at least one of whom I know that you've expressed in the recorded phone calls your affection for. I don't doubt that you are a victim of physical abuse yourself, at least from Michael Stagels. I did read statements that you made shortly after this regarding the burning with the cigarette butts, and I would deem that those statements were made at a time before you had any opportunity to reflect upon how you wanted to present this case. I don't know about the extent of the abuse at the hands of Dean Fisher. I know that the pre-sentence investigation referenced that there were no reports of that in the period of time from 2008 to 2015. I would indicate that you did not have an ideal childhood, but it's not really remarkable, at least by the comparison to the reports that I receive every week regarding defendants who have suffered far worse